And Christina, let us know when you're ready.
Okay, we are good to go, Chairman Johnson.
Much better. Thanks. You're only
Great.
live on camera for a couple seconds.
Shelley, you're ready to go?
Sorry, this is Kent with Christina Core. Are you talking to me? Can you guys hear me okay?
We
Yes.
can. We're going to be to you shortly, so we're going to go back on
Sure.
the record, and then we'll call your case.
Thank you.
Shelley, are you ready to go on the record?
Yes.
Great. Well, let's go back on the record for our September 8th, 2020 hearings. Jeff, will you please call the next case?
Thank you, Mr. Chairman. Jeff Mitchell for the record. Up next is the case that was going to be postponed till later. We were able to get a hold of Cher Ann Borst. So I would like to call case number 20-121. It is residential property. The respondent is the Carson City Assessor. My apologies. The notice of hearing can be found on page 83 of the packet. New evidence was submitted by the taxpayer.
Great. Well, first, I would like to ask that Michelle swear in anyone that's on the line that plans to testify that hasn't previously been sworn in today.
Sure. If you haven't testified already, could you raise your right hand? And do you swear or affirm that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do, I swear.
Thank you.
Great. Well, with that, the first thing we need to deal with is new evidence. And just to give you an idea of the process, how it's going to work, we have to go through new evidence. I think you submitted. There's a standard. We'll explain that to you, to admitting it. And then after we deal with that, we'll hear the case. You'll have 15 minutes to present your case. Then the county will have 15 minutes to present theirs. And you'll end with a 5 minutes of rebuttal. We'll close it, deliberate among the board, and reach a decision. So with that, let's go to the new evidence. And I want to understand, ours says it's taxpayers' new evidence. So from the property owner, can you explain the new evidence?
Absolutely.
Great.
Okay, so what we have is I have just a little bit of my situation. I did a little SBE2 is a little note letting you know what my complaint is. And then I just looked up some different NRS statutes, NAC statutes, to try to understand the process of how this gets taxed. So that's what all this is because, as you know, as Nevada, we are the only state that does their property taxes this way, which is very, has a big formula. And in getting to the formula, you have to have all this information that gives you to your taxable rate, right? Okay, so that's what all this is. So if you can go to, I stated in my first statute, my NAC was the 361.61047 determination of improvement to property. Any determination by county assessor or department is applicable that there is any improvement to the subject property must be based on a finding that there is an appurtenance, I don't know how to pronounce it, erected upon or affixed to the land, including any on-site improvement in the current fiscal year that did not exist in the immediately preceding fiscal year. Okay, so that's my statute for that. Now, if you go over to, hold on, we have, apologize, I'm not very, and then you have like SB 7 and 8. That just kind of gives you like what year it was acquired, and then what's the depreciation amount that it should be. And then this is part of their cost index and all that for the for their formulas that they use. Okay, and then I have some emails in here because I wanted you to know that I tried to get some explanation from the assessor's office. I tried, just FYI, and I tried, and I sent little emails to other people to try to help me with this because I don't know. I don't know, okay? I'm a taxpayer, but I don't know why. So, do you have any questions specifically?
I don't at this time. I want to hear from the assessor's office first if there's any objections to them allowing in the new
No,
evidence.
I look at SB 15, okay? SBE 15, page 15. If you look at that, you're going to see the added square footage and the years 1998, 2011 in number 9 and 10 for 2016, 17, 15, 16. You'll see those that were added at that time. Okay, and then you'll see further in the evidence, you'll see the depreciation like SB 31, SB 30. That gives you the percentage of good, and that's what I'm concerned about. Okay, because this stuff was done in 1987, as there's a letter in there from the gas company when they moved the gas line. I acquired the house in 2008. Okay. So if you have any questions, let me know. And if not, we'll just go ahead and hear from the assessor's office.
Great. And I don't have any questions. If I do need any clarification, I'll come back, but I want to hear if the assessor has any objections to this new
Thank you.
evidence. Thank you. So Carson City, to you guys to let us know if you have objections to the new evidence being allowed in.
Good morning, Mr. Chairman. Can you hear me well?
I can, Dave. Good to see you.
That's Travis.
Travis has.
Oh, Travis. Okay, I'm having trouble. Apparently I can't. I love my iPhone.
So with the new evidence, we do have an objection to allowing it straight up because it was brought to the county board as was, and everything else is public information.
So this is Dave Dolly. All of this information itself was hashed out in the county board. I know you have the hearing that you actually listened to. There's no new information in this new evidence, and so we see no.
Other than it's covered at the county board.
Well, here,
Ms.
let
Morris,
me.
it is our turn.
Yeah, it has to. It's Carson City's time to talk, so we can't talk over them. And so sorry about that, Travis. Dave, please do continue.
So anyway, we object to the new evidence because we believe there is no new evidence in this.
Okay, it's all redundant or stuff that was already considered by you guys
Correct.
at the county board level.
Correct.
Okay. With that, Michelle, just in helping us to determine, can you read or give the board the standard for consideration of new evidence?
Sure. So this comes from your regulation NAC 361-739. And the new evidence could not, by due diligence, have been discovered or secured before the final adjournment of the county board. And it must be provided to the state board and all parties of record 7 business days before this hearing.
Okay. That's helpful to me. Now from the taxpayer, my question would be, A, do you provide this information 7 days before? And then B, the emails were subsequent to the county board. I understand that, it looks like, but the rest of the information would have been in the record already. So can you offer some type of response there as to why we should accept it under our standard for review?
You're asking me?
Yeah.
I just want to make sure. Okay, so I just want to make sure it was my time to talk. Thank you.
Yeah, it is. No, thank you.
Thank you. So, yes, so I was having issues with getting, organizing this where it would be easy for me to tell you my story. And I apologize, but I don't do this for a living. I don't know how this works. And I'm new and I'm sorry, and I'm not very bright at this. And I apologize, but I'm trying. Okay. So I'm trying.
Okay. No, that's great. Let's close it then and let's see what the will of the board is. This is just relative to the issue of allowing in the new evidence, and we'll proceed on to the case. But I think we've heard from both parties. I think we're able to make a decision. I would welcome the thoughts of the board relative to how you want to vote to the new evidence, allowing it in or not allowing it.
I heard that it was not new evidence that had been presented to the county board. And this is just a resubmittal of the same material.
Yeah, with the addition potentially of a couple emails, but the emails I'm seeing are sent in 2019. When I looked through it, I don't know if I missed something in there. But it looked like mid 2019 emails primarily. Al or Bob, do you guys have any thoughts?
This is Bob Schiffmacher. As I look through the information that was submitted as new evidence, I don't really see anything that either is not part of, not necessarily this record, but the public record at large, or anything that's particularly probative to the problem at hand. And I agree with you, Ben, that it appears that the emails that we're looking at were ones that would have been available prior to the county board hearing. And so I'm not sure that there's anything in this that really helps making and bolstering one argument or the other.
Yeah, the only reason I would be inclined to allow it in, but I really want to go with the will of the board, is it's all information that was available. The assessor is aware of it. If it helps the property owner to organize her thoughts and presenting her case to us. But I don't know if I'm giving way too much latitude there, because all this information was available prior to the county board. And there's nothing that would prevent the property owner from using this information to present her case today, because that's all part of the public record. So she could use it as a basis to highlight her thoughts, because all that information's out there, it's public. But
And
I'm
this is
open
Al.
here.
I also have the sentiment of allowing the taxpayer latitude, but I believe that by preparing this, she has she has it organized in a method that she feels comfortable in presenting, but sticking to the strict rules of new evidence, I would motion that we do not allow it as new evidence, strictly because it doesn't meet the standards of new evidence, the strict standard of new evidence.
Great. Do I have a second for that motion?
This is Bob Schiffmacher. I second that motion.
Awesome. Any other comments? Seeing as none, all in favor, please say aye. Aye.
Aye.
Any opposed, say nay. Motion carries unanimously. So we didn't allow in the new evidence, but to the extent it helps with your thought process in presenting your case, feel free to use it during your 15 minutes. I mean, you can't directly rely on it, but all that information is already in the record. With that, let's move on to the case itself. Carson City, will you guys identify the property?
Good morning, Travis Haslam, Carson City Assessor's Office. Subject property is a single-family residence that is 1,032 square feet, located on a 0.15 acre lot on Rawhide Way. The home was built in 1970, and it is being used as a single-family residence.
Great, thank you. Property owner, you've got 15 minutes. And before, and my apologies, I just didn't want to, your name is Sherry, is that correct?
It's Cherie. Mm-hmm.
Cherie, okay, I just didn't want to mispronounce it, so I'd been hesitant there. Cherie,
Yes.
Thank you. Yeah, you've got 15 minutes now to present your case. So feel free to do it however you feel.
Right. So my case is that I feel, I'm going to read this, that I'm being taxed for new addition for something that really is 33 years old. That's simply not fair. The basic problem is the appraisal of my property shows an improvement in 2016, 2017. Not true. The value of the appraisal in today's dollars having a huge impact on my property tax. Looking back to 1987, when the value of the improvements were most likely a quarter of today's prices. I'm being penalized for a previous owner's improvement in 1987. The city's failure to appraise the addition and then depreciating it from that time frame. Again, when I took title of the property in 2008, The addition should have been built into the overall tax structure at that time, where the depreciation should have been applied for 20 years at that time in 2008 when I acquired the property. Then the property should be depreciated for another 8 years in 2016 and 4 more to 2020. And if you see that public knowledge that you said, SB 24, you can see it's 91% good in 2017, 2018, which does affect my taxes. And there again on improvement number 10, it's at 89.5% good, when the rest of the stuff is at 28 and 30%. That all has effect on the overall tax structure where we get our property taxes. It does. It has an effect on it. Maybe it's small to some and larger to others, and it's larger to me. Anyway, I don't make $160,000 a year. I would like to refer to the taxing guideline that addresses the situation like this, the NAC, the 361.61047, the determination of improvement to property. And I just do not think that this is fair. There's evidence of the pictures that have shown from 1998 to 2017. You can see the roof structure. There's nothing that has changed in this property since 1987. As far as the roof structure, nothing has changed. Nothing has changed since I acquired it in 2008. Nothing. Okay? And I think that's all I have to say.
Okay, so your argument, I want to make sure I understand it correct. It's hard when we get the entire packet and there's a lot in there, but it's that existing property was added to the roll at a later date. It was discovered, added to the roll, but it was added to the roll at a current base year. And it had been
By new computer systems. Now, I don't think this computer system takes into consideration all the NACs and NRSs, okay? Because it just doesn't. I feel that the numbers were not calculated correctly.
Okay, so it was improvements that existed prior to 1987 or 1987. Now you don't feel like they've been adequately depreciated under the 1.5% a year.
Absolutely, sir.
Okay. Well, perfect. I just wanted to clarify because that allows me to ask more specific questions.
Sorry.
Go
ahead.
Any other questions of the board of Cherie?
Cherie, this is Bob Schiffmacher. Can you point me to the page that shows the
roof structure?
No, the valuation of the roof structure and the valuation of that portion of the property.
So I can show you the part that, so the SB 30, let me see the original page. It's going to be SB, I apologize. All this information, SB 15 to SB 31. That will show you all of the, how in 2016 and 2017, you can see how the years is all 1970 until you get to number 9 and number 10. And that changes to 1998 and 2011. And you see that.
Based upon the files I'm looking at, that appears to be the taxpayer new information, not the.
But it's right on the website.
File.
You guys didn't want to let this in, but this is how I can direct you to it.
Yeah, and I'm okay, Bob, there with, I mean, just tell us if that's authentic or not, but I'm okay. I mean, if that's the issue, I want the information.
So to clarify, if I was looking at the table that's on page SBE 15 of the new taxpayer information, the only item that is at issue is this the patio cover with a date of 2011.
And the one above it in 1998. You have those two right there. And if you follow it, if you go back a little ways, you're going to see 2014, 2015. It doesn't have those on there.
So, okay.
It also changes the square footage for number 3. It changes to 480 from to 384.
So that'd be a benefit to you, right?
Well, hello, that's not really a benefit when you add the 396 and the 125.
Yeah.
Sorry.
Oh, no, I was just, and what we're, I mean, I just want to be able to ask questions of
Oh,
the assessor.
Absolutely. It would be a benefit if you didn't add the other two numbers. Absolutely. But it,
Yeah, overall, you're
And-
saying aggregate, and
Yeah.
it looked to me like
and
new.
then if you go to see, like, okay, if you go to page 22, you're going to look, number 9 is at 70% good. Okay. And then 71.5, because it only lowers by 1.5% a year. So you're going to go from 2017, 18, you're going to, number 10 is 91, and then number 10 is 92 on 16 and 17. You see the percentage, and that all has to do with the formula that you get for the property taxes.
So Sherry, to clarify, those improvements based upon your records were constructed in 1987?
That is correct, sir.
Okay.
Any other questions of the board members at this point? Seeing as none, we're going to go to the assessor's office, and then we'll come back to you, Sheree, for your final 5 minutes. Assessor's office, I know that you're probably going to go through sales, other items that weren't specifically discussed, but if you could provide some guidance relative to Sheree's comments relative to, it looked like property that was newly discovered based on what I was seeing and just the depreciation of it and how it was added to the roll.
Right, Travis Haslam, Carson City Assessor's Office, for the record. So those improvements that were picked up were done in the last reappraisal cycle. And as time's gotten better with the aerial photography, that's when we discovered those. And the one in 1998, that's the earliest day we have aerial photography. So that's when we picked it up. And those improvements are not permitted. So there's no date to track them besides an email from the gas company, I believe it is. And the 2011 one, I believe that's when the aerial looked best. And then that one correction she was talking about, that was just a correction of better aerial photography where we can measure better.
Okay, and with that one, the correction, you guys reduced the square footage. It looked like you measured and hey, we're trying to do our job right.
Correct.
The information we have.
And this is Dave Dolly, and I want to go on the record and just say that when the county board heard all of this information, and we had actually said that we would lower the age of the structures back to 1987, but then at that point, Ms. Borst said, no, it was built in 1980. And so we're trying to give the benefit to the taxpayer, but the taxpayer keeps changing the dates. And so we don't have without any kind of permits, without any kind of aerial photographs. I mean, we did the best we could going back to the aerial photographs to see that that was the year that it was actually constructed.
Okay, and what do you do, Dave, in other similar circumstances? I mean, this can't be the only one where, hey, we just find property that was escaping taxation, we add it to the rolls. We've got to establish when it was constructed, and you guys are limited by aerial photos or building records. Is it standard fair practice to we're going to go to the state we can find that we know it existed?
That's correct.
Okay,
I apologize. We're actually doing a lot more reappraisal through the aerial photographs because they are getting much better and much easier to see. And so when we find something, we are doing our research. We are going to the building department to see if there's any kind of a building permit on it. We go back to go back in time to see to the earliest. I believe the earliest photographs we have is actually 1998.
Correct.
And so we do go back to and try and verify all the information. If we find something that hadn't been, for instance, let's say in 2015, somebody put something in there, but we had just done reappraisal in that area, we will, the next time we go out to reappraisal and we see that information, we will actually take it back 4 years because it could have been put in 2015. It could have been put in 2016. We do give the benefit to the taxpayer. In this case, we went back as far as we could, as far as the aerial photographs were concerned. Again, there were no building permits issued. And so we did the best we could in determining what year to put on these structures.
Okay, in a global sense, these improvements existed. I mean, whether it's 98 or 87, they have existed for at least the last 20 years. And it's until recently they're being added to the roll. So you guys didn't pick them up, but the property taxpayer did get the benefit of having zero assessment assigned to them for a period of time.
Chairman Johnson, this is Christina. Could you repeat the question that you asked the assessor before they just answered, because you cut out and our court reporter wasn't able to get it?
Okay. My question just now was, prior to you, the assessor's office adding these improvements to the roll, and when they were installed, regardless of when they were, we know there's a gap, significant gap, decades between. For that period, the property owner got the benefit where they didn't pay any taxes on those improvements because they just weren't discovered through normal methods of assessment.
Mr. Chairman, if I might be able to add just a couple more comments. What happens when we find information like this, or when we find improvements that are added to the structures or the parcel itself, we don't add it as new. The property tax cap says that anything that's constructed new to the roll or to the parcel has to be outside the tax cap the first year. When we discover something in the reappraisal cycle, we do not add it as new. So it's not outside of the property tax cap that value was added onto it. And so again, that's a benefit to the taxpayer that we provide.
Oh, wow. I didn't, and this probably goes further than the board. I didn't understand that. So they still get the protection of the tax cap in addition to depreciation relative to the year within reason you guys can establish that the improvements were there going back. They're getting kind of both benefits.
That's correct.
Depreciation and falling under the tax cap.
Yes, that's correct.
Okay. That's helpful from my end. Board members, do you guys have any other questions of Carson City?
This is Bob Schiffmacher. So at this moment, based upon the actions of the county board, what is the effective date of construction of these specific improvements based upon the current record?
Sir, Dave Dolly, Carson City Assessor. So that we suggested that we would lower the values, or I'm sorry, lower the age to 1987, but the board kept the actual years that we had. And so one is 1998, the other one is 2011.
Okay. And the total, and I've done the math, and so I'm going to ask for your indulgence. The total value of those improvements, the replacement cost new of those improvements, is approximately $19,200 for the two components. And the current taxable value after depreciation is approximately $14,000 under the current.
Is that correct?
Are you talking overall site improvements?
No, just
these two improvements, the two improvements at question.
With the current fiscal year approaching, I have slightly less values at taxable value.
Okay, but we're in the same ballpark.
Correct, sir.
So if we were to drop the effective age or the effective construction date back to 1987, the taxable value for those two specific improvements would drop to about $9,705 total for those, the combined total of those two.
It would be slightly over that for us, because if we were to do a 1987, then the cost for the cover would be $717, and then the solid wall enclosed porch would be $10,337.
With the 1987 value.
Correct. Yes.
So in round numbers, it would drop the total taxable value by approximately $4,000.
Yes, sir.
And if I understand the balance of the record, this property is benefiting substantially from the tax cap that was instituted in 2005. And this $4,000 change in the total taxable value would not impact the assessed value base that upon which the taxes were calculated.
Correct. There would be no decrease in taxes.
Okay. Thank you.
Any other questions, Al, Glenn of Carson City?
I think Bob nailed it.
Yeah, I do too. I mean, that was really helpful from my end. Any thoughts from you, Al?
No, I'm in agreement with Bob as well.
Okay, great. Well, with that, I don't have any more questions from Carson City. Cherie, we're going to come back to you for your 5 minutes for closing.
Okay, sir. So I just wanted to know the format. How did they come up with the ages? How did they come up with that in doing this? Because they never informed me either that they were adding this stuff to my tax roll. I never got a certified letter. I never got information saying that they were adding this stuff to my tax roll. All of a sudden, my stuff goes up. I had a situation before when the city made an error, and I got a certified letter at that time when they made an error at that time. But this time when they made this error, I believe, I didn't get a notification of that other than my bill.
So the
Okay,
error,
what they...
go ahead, Ben.
Oh, no, Bob, go for it. I'm fine with that.
So the error that they made was the error was not that they added these improvements. The error was that they added them with the incorrect construction date.
Correct.
Is that correct?
Which affects the overall formula for getting to your taxable amount. Yes.
Correct. Okay. And the difference based upon my calculations between what the property is currently, the taxable value of this portion of the property is being valued at, and the value that would be used that would result from the 1987 taxable value or the 1987 construction year.
Yes.
Is a difference of roughly $4,000 in taxable value, or about, well, and again, these are rounded numbers just because I don't have it.
That year, sir. I'm sorry to interrupt you. I apologize. But you have to think about that every year since 2016, the value that they've overcharged me since that date, though.
Those tax years are the opportunity to appeal the taxable value of those years has expired.
3 years.
The only tax year that we can address now is the tax year that is subject to this particular appeal.
Right. Okay, so what about the whole COVID thing made us later as far as, just a few months, but so there's no way to go back and change that from 2016, 2017 to 1990 to 1987?
That's correct.
For the prior tax years.
For the prior tax years.
But when I went to,
But with a point, no, but I think an important point here, and it's beyond the scope of this board, but I do think just in helping you to understand is this overlaps with the property tax cap. So as a single family residence, that is your primary, you qualify for a tax cap on your property, and they're saying that the value.
Point, I pay that though, right?
What was that?
At some point, you have to pay the tax cap when your property drops 15% or whatever. You have to
in the future you could. But
yes, thing that too. That all goes into this whole formula. It's all part of a formula, and that's my complaint: is this whole formula.
Okay, yeah. And my comments were more, and you had a couple tax years since it had been added. It doesn't appear that adding this has over the last 3 years resulted in an increased tax burden, but there is a potential in the future, which is your argument, if I'm understanding. Okay. Yeah. Well, that's fine there. I want to go to that So you've gotten there a letter from 1987 from Southwest Gas.
Yes.
Because
only
really the quantity
evidence
find.
that I could come up with, because I apologize, but that's the only evidence I could come up with. I was how old was I? I was 17 years old, 18 years old at the time. And then in 2008 is when I acquired the house. Yeah. Okay, go ahead.
What we're trying to do here, because what the assessor's office said is they realized there were improvements. They're trying to do the best they can. And they went to aerials to the earliest date they had, and they saw the improvements there. So as a board, our challenge here is it 98 or is it 87? And what's a reasonable basis to establish that base? That's where I see it.
SBE 53. That gives you a little bit of SBE 53 gives you what that was available on the website before you guys got your new computer system this last year. And I know that because I called the company, and I know when you guys got the new computer system. It says in my evidence, I have it all written down in there. And so as of this year, SB 51, that's all brand new. That's brand new this year.
I'm seeing SB 51. Let me make sure I'm looking at the right page. Okay, I'm making sure. Okay, that's the property details for your parcel, correct?
Yeah, and then SB 53 is what the sketches that they had in the system before that. Okay, and then and then SB 50, that's the computer system when you guys got new ones and stuff, and tells you. So I'm just wondering how come they didn't notice it in 2014, 2010. I mean, that's when they got new computer systems each year. I just don't understand how come I have to pay for that.
No, and what we're trying to do, I mean, the assessor has a very difficult job that I don't envy, and all of Carson City trying to capture all the property that's there. That's not an easy job. And they're constantly trying to go out and do a better job each year, which I very much respect. So it's here, if there's a reasonable basis for those improvements, the assessor office said, we have aerial photography. I think it was 1998 was their year. We can establish the improvements were there. We can add them on the record as of that year, but you're still saying 87. So there's an 11-year gap. So I was wondering if there's anything you can add context wise to help us feel comfortable with a specific year.
I apologize, but the person I got the house from passed away, and someone stole from them and took their money. So I don't have any of those important records. I don't know where they went. I don't know.
So,
I'm sorry. This is what I have.
This is Bob Schiffmacher. Can you point me to the letter that came from Southwest Gas, please?
Absolutely. I have it in there twice, just so you know. I did it accidentally twice.
I remember reading it. I just can't put my finger on it.
It's SB 45, sir.
45.
Mm-hmm.
Bear with me just a moment.
You're fine, sir. Thank you.
Okay, I have found it. Thank you.
You're welcome, sir.
Any other questions from the board? And Bob, did you have any follow-up questions after?
No, I'm going to, I eventually will probably end up making a motion, and that letter will come into play during that motion.
Okay, perfect. I just want to make sure you had what you needed. It sounds like Alan, Glenn have what they need. So with that, we're going to close the hearing and deliberate as a board. Bob, as it sounds like you have some thoughts, I would be open to hearing them.
Well, I think that I do have, this is Bob Schiffmacher. I do have some thoughts. I think that the Tax Reform Act that resulted in the tax caps, in combination with the unusual economic conditions that existed over the last decade and a half, have resulted in a situation where some of these changes will not affect the taxes that the taxpayer pays because of the tax cap. The valuation of this property, while the calculated numbers for the taxable value will change because of the tax cap, there will be no impact on the taxes that are paid. I think it is incumbent upon the assessor to make their best effort, given the information that's available when they pick up old improvements, to establish an accurate construction date. And based upon the information that they had at the time, the 1998 date of construction appeared to be reasonable, because that's the first time that they had documented information regarding the when that improvement may have been constructed. I think that this email that Cherie was able to obtain from Southwest Gas provides additional information that may not have been available to the assessor at that time. I find that this is adequate information in my mind to suggest that the construction date may be back in June of 2000 or 1987. And so based upon that, I will eventually, if I'm given the opportunity, make a motion to instruct the assessor to establish the construction date of these two particular improvements to be 1987, but keeping in mind that although it will change the taxable value by approximately $4,000, the taxpayer needs to be aware that it will not change their tax obligation.
Yeah, and this year or any past year, and obviously going forward, who knows with the market? I mean, if the market goes down by half or something, which I don't see how that's reasonably possible, but if it did, there's a future year where it might affect their taxes, but that's pretty hypothetical. But correct. I agree, Bob, with and the only thing I would add is the assessor's office appeared to be amicable to going back to a 1987 base year, based on everything that was discovered through the appeal. And the only reason that was their recommendation, it looked like, to the County Board of Equalization, if I understood Travis' testimony today correct. With that, Al, what do you have to say here?
Just a couple observations. Is the assessor's office seemed to be willing to take it back to an earlier date of construction. We have sworn testimony from the taxpayer that it was an earlier date of construction, and I think the accuracy is what we're after. And so I agree with both your observations that I don't have any qualms about a motion that would go along those lines.
Great, thank you. And Glenn, any comments from your ends?
I have no comments about reverting to the 87 year. And I'd like to congratulate Siri, Ms. Borst, for the fine job she did collecting all this information.
Duly noted on that. And I agree as well. She was well prepared. Ton of respect for that. With that, Bob, it sounds like you want to make a motion.
Well, I'd be more than happy to, Mr. Chairman. In case number 20-121, Cherie Borst, I move that that we accept the taxpayers' information and have the date of construction for the two improvements at question changed to June of 1997, and
80?
ask that
80 or 90?
87,
Okay.
based upon the letter or the email dated December 4th, 2019 from Southwest Gas, and ask that the assessor make those changes to the taxable value as calculated, but keeping in mind that the taxable value for the purpose of the tax cap will not be modified.
Do I have a second?
I'd second that. This is Glenn Trowbridge.
Great. Any comments from the boards before we vote? Seeing as no comment, all in favor say aye. Aye.
Aye.
Any opposed, say nay. Seeing as none, the motion carries unanimously. Thank you guys for that. And Jeff, we are, I think, ready for the next case. I want to make sure that Shelley's okay with what could be another half an hour, 45 minutes. I know it does run into lunch. And the staff of the Department of Taxation is also okay with that.
We're fine at the assessor's office.
Okay, great.
We're fine.
Thank you.
Thank you.
Thank you,
Bye-bye.
Sherry.
Bye-bye.
And Shelley, I just want to make sure I heard from you. You're okay if we go for what could be another 45 minutes right now through lunch?
Yes, yes.
Okay.
Thank
Well,
you.
with that, Jeff, let's call the next case.
Thank you, Mr. Chairman. Jeff Mitchell for the record. Up next is case number 2151. This case appears on your agenda twice, both under agenda item C and agenda item D. Originally, we received an appeal from the County Board of Equalization for the 2021 tax year. Upon the form for the State Board of Equalization was also mention of other tax years, the 15-16, 16-17, 17-18, and 18-19 tax year. So it appears on the agenda twice, once as a jurisdictional issue for the previous tax years, and first for an appeal from the County Board of Equalization for the 2021 tax year. So I just wanted to provide some clarification as well as some commentary on that.
What's your thought relative to hearing them individually? I think the issues are distinct and separate relative to how we're going to decide there. It looks like untimely filing for the prior years. So do you think it's cleaner to hear them individually, or should we hear them all at once and then decide the years individually?
Perhaps if we could reach out to the respondent and petitioner and gauge their interest in pursuing that.
Well, respondent and petitioner, I'd welcome your thoughts relative to if we should combine into one or we should hear the issues separate.
This is attorney Michael Matuska in Carson City on behalf of the petitioner Christina Court. I just want to make sure that that the audio and video was working first of all.
It is. And Mike, before we go any further, I guess, did you get sworn in before today? Or do you just?
No, but I'm planning on I'm really here as an attorney. We do have a representative from Christina Court on the line with us, Kent Merzlock. He could be sworn in if he probably should be.
Yeah. Anyone that's on the call that hasn't been sworn in yet, Michelle, will you please swear them in?
Sure. If you haven't previously been sworn in, if you could raise your right hand. Swear or affirm that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Wonderful. Now that we've established that, back to you, Mike, relative to how you're suggesting we proceed. My question was, it looks like there's two different issues. One's a late timing, late filing, and then the second is hearing the case on its merits. And I think the arguments for why we should accept late filing for prior tax years may not overlap with the merits of the current tax year.
Well, I'm not sure if you're just referring still to the to the exemption issue, the two issues that I'm looking at, we have the exemption issue, and then we also have a value issue. We've been requesting application of the income approach. If I can add though, even since we went through the appeal before the county board, or contemporaneously with going through the appeal with the county board, the county accommodated Christina Court to some extent. They allowed the exemption filing for the 2019-2020 tax year. And so as it now stands, Christina Court has been granted the exemption for the 2019-2020 tax year, and also for the 2021 tax year. But we are requesting a refund for the prior 3 tax years, and we still need to address the income approach to the valuation. Does that clarify where we're at?
Yeah, it does. That's helpful from my end. And what Jeff was proposing was that we call these cases all together. They've agendized the prior tax years, those 3 prior tax years you referred to, separately, with the recommendation to dismiss because they're an untimely filing. And then your guys' arguments relative to the income approach for the current tax year, to hear that separate. It sounds like you guys would be fine with hearing them all together as one, and then we can make individual decisions as we see fit.
Yeah.
The board.
Yeah.
Okay.
Yes.
Okay. I don't have any issues with that, but I want to hear from the assessor's office relative to if they have any objections before we combine.
Thank you. Kimberly Adams with the Carson City Assessor's Office. We have no objection to hearing them together.
Okay, great. Well, Jeff, please call both cases, and we'll hear them together.
Mr. Chairman, can I just add one item or one thought? This is Bob Schiffmacher. I want to note that, as you had indicated, the issues regarding the item that are on agenda item D regarding the jurisdiction are distinct and separate from the appeal listed under agenda item number C, and I'd suggest that we acknowledge that and provide the taxpayer additional information during his presentation and rebuttal to address those items separately, because they accrete to the same property. They are different. They have different contextual arguments.
Okay.
So I don't want to.
Because we're combining, so we give them more latitude with time to fully explain to the board. I'm agreeable to that.
Okay.
So with that, Jeff, unless there's any other comments from the board.
Thank you, Mr. Chairman. I would like to call under agenda item C and D, case number 20-151, Christina Court as the petitioner. Notice of hearing can be found on page 537 of your packet. The respondent is the Carson City Assessor. It is multi-family residential property. There is new evidence that needs to be addressed first.
Great. And Michelle, can you give us our standard review for new evidence?
Michelle, you're muted.
Is that better?
Yeah, we can hear you now.
Sorry. Okay, so this comes from your regulation NAC 361-739. The new evidence must not have been available for the county board, and it must have been provided to all parties 7 business days prior.
Great, thank you. And now to Mike, I don't know if you're the one that's, or it's both you and the property owner, but under that, can you give us some guidance relative to why you feel we should accept the new evidence that was submitted?
I'm not quite sure what you're referring to.
We have a file that we were given, and it's a letter from your office dated August 14th, 2020 to the State Board of Equalization, and that was considered new evidence. So to the extent we're going to consider it today, what I wanted to hear from you is why you feel that this meets the standard for new evidence and we should allow it in and allow it to be considered as part of our discussion.
Well, it meets the standard because that was a response to the notice of appearance and notice of hearing, which really did not give any detail on what issue had not been accepted for appeal. So that was confusing. That letter was simply requesting the clarification, and I did not get a response to that. So we have not been completely certain on what issues were identified on the notice of appearance that the county board did not accept jurisdiction of. I don't think that's clear, but honestly, I don't know that's going to affect what we do. It sounds like we're covering our case as far as we need to.
Yeah, and that's what I got to, is we're going to allow you guys to let us know why you feel the prior tax years should be considered, even though it appears to be an untimely filing. That was part of the combining, in my view.
Yes.
Okay.
You refer to request for exemption being an untimely filing for the prior. Yeah, for the prior tax years. As we explained, the assessor accommodated Christina Court for the 2019-2020 tax year anyway. So we're talking about the prior years.
Okay. Carson City, what's your thoughts relative to the new evidence and if we should allow it in?
We have no objections. It's basically in the record from the county board, so we have no objections.
Great. Board, what's your thoughts and or motion?
Then this Bob Schiffmacher, based upon my review of the information that's provided, I think that having it as part of our record will provide substantial clarity to any further arguments. And so I would suggest that we allow, in this case, this information to be included.
Is that a motion?
I would move that we accept the taxpayer new information as presented.
Great. Do we have a second?
I'd second that motion.
Wonderful. Any comments? Seeing as none, all in favor, say aye. Aye.
Aye.
Any opposed, say nay. Seeing as none, the motion carries unanimously. The new evidence is allowed in. Now let's go to Carson City Assessor's Office to identify the property.
Thank you. Kimberly Adams, Chief Deputy Assessor with the Carson City Assessor's Office. The item before you today is Assessor's parcel number 002-10188. It is a 1.77 acre parcel located at 1800 Russell Way with a 39,086 multifamily residential apartment building consisting of 40 units that was built in 2012.
Great. I appreciate that. Now let's go back to Christina Court. You guys have time and we agreed to allow additional time so you can have all of your issues heard. I'm not sure who's going to be giving the presentation today on your guys' behalf, but feel free to proceed, walk us through the issues as you see them and the relief you're requesting from this board.
This is Michael Matuska. I will lead then. I just want to make sure that how the evidence package is numbered. I have an evidence package 1 through 438 that we had before the Carson City Board. Is that the same package that this board looks at?
No, we've got a package that's numbered with SBE numbers on the lower left-hand corner, and it goes through page 540. So there were some additional pages And I assume you've prepared, Mike, based on your records. So I want to do what we can to minimize having you have to also think about page numbers as you're going to give us sites.
It's probably in there, but that's one of the things that I asked in that letter was to be provided with a packet that the state board had, so we can make sure that we're looking at the same thing. But I have to presume that the bulk of your package is what was presented at the county board.
Yeah, we should have the entirety of what was presented at the county board, and then extra information, the appeal sheet to the state gets added in, and then a summary of what happened at the county board.
Okay, so probably
so we do have it all. I just think the page numbers are going to get off a little bit. So my recommendation, we'll work with you there. I want to make it as easy for you and allow you to focus on the important issues. If we're not, we've reviewed it. If we're struggling, we might stop you and say, hey, Mike, we're just struggling to find that page, struggling to look at it. Can you help guide us there if that works for you?
Okay. Well, I want to point this board to the initial land use restrictions. In my packet, that's page 58.
Mike, is that the March 17th document?
Should be October 5th, 2011. I'll double check that. I'm looking at, I want to point the board to the original land use restrictions and to the amended land use restrictions.
Okay, the amended ones are the 2013.
Right.
Okay. And I think your declaration, I think it starts on SBE 88 is my understanding. That starts with declaration of restrictive covenants renting with the land for low-income housing recorded October 11th or October 5th, 2011 at 2:52 p.m.
Yes.
Okay.
Ben, that's page 88.
Correct.
And then we have an amended version.
Yeah, and that's going to be previous in the record, right? About, and I'll just make sure we're on the same page, Mike. I get a recorded document number 431668 that's recorded February 27th of 2013. But that's a deed of trust and security agreement and fixture filing. So I don't know if that would be the one you.
No, there should be. Let me find the amendment in the package.
And I did. I'm looking for it too, Mike. I think there was.
Would it be the next? I've got one dated March of 2012, March 15th, 2012 at page 104.
Our numbering is off, but that's what's the title of that one, please?
The date is March 7, 2012, declaration of restrictive covenants running with the land for low-income housing tax credits for Christina Court Apartments.
Okay, yes.
It's recorded at document number 420376.
Yes.
Okay.
Yes, thank you. That's the amendment.
Great.
It's re-recorded, and then you can see there's another document, March 20th, 2012, which is the release of the declaration.
That's the release of the first declaration?
Yes, and thank you. That's the point that I wanted to make. The release was a release of the first one. There's always been a declaration restricting the use of these buildings on record.
Okay. And that, I mean, yeah, that makes sense to me because that's recorded March 20th and specifically October 2011, prior as a release.
I wanted to point that out initially because there's an email from the assessor's office. February 9th, 2016. That was Exhibit K at the hearing at the county board. That was page 383 in the packet before the county board.
Okay.
And Mike, you say that it's Exhibit K?
Yes.
And I'm looking for it right now.
I've got it at page 435, 436.
Yes.
Exhibit K Exhibit K is actually an email chain.
Yes.
So I'm looking at the email from Pat Marker to Kimberly Adams.
Dated February 8, 2016 at 11 a.m.
Excuse me, no, it's the next page. It's the one from Miss Adams to Pat Marker on February 9th, 2016 at 9:51.
Okay, I've got that one in front of me.
And that's, so that's the 437.
Yes, that's the email from the assessor's office, essentially to the property manager for Christina Court. And part of the email says, per the attached, the declaration of restrictive covenants running with the land were terminated. That's explaining the reason in 2016 why Christina Court was not eligible for the tax exemption. We have a series of emails prior to that, going back to 2012, 2013, explaining that Christina Court is not eligible for the tax exemption because it is not 100% restricted to low-income housing. It's 90% restricted to low-income housing, essentially 36 out of 40 units. But the initial emails were that it did not qualify at all. And then this later email that it did not qualify because the land use restriction was terminated. And that is simply a mistake. As we just saw, the land use restriction was not terminated. And our legal authority is NRS 361.768, subsection 1, which is if an overassessment appears on the tax roll because of a factual error concerning its existence, size, quantity, age, use, zoning, or legal restriction, the county assessor shall make a report thereof. And that statute also says that that the adjustment may be a full refund of a period no longer than 3 years. So that's where we get the 3 years from. NRS 361.768. And I would respectfully submit that there really should be no dispute that there was a factual error concerning the legal restrictions against the property. So that's how we get to the 3 years. And I can make a simple explanation regarding our request for the income approach to value. And that also involves NRS 361.768, looking back three years. But very simply, also preceding and as part of the as part of the hearing before the county board, Christina Court asked for the income approach to value to be applied. The discussions between the county board were confused. We never really got a definite answer why or why not. There was just a general motion to accept the value as is. But I want to explain a little bit. I attached to our notice of appeal an addendum that provided a longhand explanation of these factual issues, and also attached the 2021 notice of assessed of the value assessed. The taxable value for fiscal year 2019-2020 by the assessor's office was $3,204,302. The total assessed is $1,121,506. And that is substantially higher than the value that Christina Court places on this apartment using the income approach. And we did have a discussion at the county board that Christina Court's numbers supporting the income approach to value we're using the actual values, the actual rentals received for this for this income restricted apartment. The value that the assessor was using uses the market rents. And the assessor went on to explain that actually, if they applied the income approach using the market rents, their values would be a little higher than what is shown on the notice. So they didn't use the income approach. But the dispute or the conflict was that the assessor is making that statement based on the market rents rather than the actual rents achieved for this income restricted property. And I think that gets us back to the land use restriction again, and gets us back to NRS 361.768, which allows the assessor to look back three years, because their approach of using the market rents instead of the actual rents, I have to submit, is part of this same mistake, that they thought that the land use restrictions had been terminated and they were not using the actual values for a rent restricted building. And I can point out the different income sheets that Christina Court submitted and that the assessor relied upon. Christina Court submitted an income statement dated December 31st, 2019. And Mr. Johnson, I don't know, I'd like to direct you to the page. I'm not sure what page it is in your packet. It's page 287 in my packet. It's almost toward the end of the of Christina Court's evidence, about 10 pages before the commencement of the assessor's evidence.
I'm looking now.
Mike, is there an exhibit number associated with that?
I've gotten maybe a SPE 474, looks like an income statement.
Dated December 31st, 2019. No, we did not have, this packet was not broken down with exhibit numbers. The assessor's evidence was broken down with or numbered with letters. Christina Court's evidence just runs with consecutive page numbers.
What's the date again? December 31st, 2019?
In Christina Court income statement, December 31st, 2019.
Gentlemen, if you'd look to page 323, I think that's where we are.
It's year-to-date, December 31st, 2019, starts with rents, $213,645.
Yes.
Yeah, and ends, I just want to make sure we get down to the bottom. It shows not net operating loss of $96,527 a couple pages later.
Well,
Yes.
it's an income or loss.
Yeah, no,
Yeah.
sorry, income. So income of 96,000. I just want to make sure all the numbers through, and then we adjust net operating income by adding back in real property taxes. But it sounds like that's the document, and it's
Yes.
3 pages.
Yes, and then I would refer you to Exhibit T in the evidence provided by the assessor. That was their income approach to value.
Okay.
And these documents pretty much need to be compared side by side. For ease of reference, the expenses are very similar on both Christina Court's statement and the assessor's statement. But the revenues on the assessor's statement, Exhibit T, are dramatically higher.
And that's due to market versus restricted rent under the covenants, I assume.
Yes. Christina Court's, what's showing on Christina Court's income statement are the actuals.
Okay.
And the assessor explained at the hearing that their Exhibit T, their income approach Exhibit T, was using a market rent analysis. And the assessor explained, therefore, that actually their income approach using the market rents generated a taxable a value that's actually a little higher than what is shown on the tax statement. But I never succeeded in clarifying that before the county board or getting a resolution. That still overlooks the problem that I'm explaining, that's based on the market rents. If we take the income approach based on the actual value, we wind up with a drastically different value. And that is shown on Christina Court's income approach. They go through the analysis, wind up with an income, a value cap, $611,035.92. And so that is different. We have this situation now where, at least going forward, 90% of the building will be tax exempt, but these values will ostensibly apply to the remaining 10% of the building and will influence the tax accordingly.
When did the 90-10 split start? Has that always been in place? I just saw some documents that it was 100% deed restricted, and then 90% comes up as well.
It was never 100% deed restricted.
Okay.
The initial restrictions were 90-10. The amendment, it actually extended the restrictive period and made another change, but did not affect the percentage of the restriction. Mr. Merzlock, the client representative, is on the phone, and he's well-versed in the value and appraisal issues and can explain to the board why an income approach to value is preferred for such a building. I'm not sure that is necessary, though, because there wasn't, at the county board, it didn't sound like there was an objection in theory to using the income approach. But as I've been explaining, we disconnected. We had that difficult presentation and hearing. They explained that their income approach would produce a higher value. And I kept asking, but we need the income approach based on restricted rents. And we never got that resolution. So Mr. Merzlock can explain why the income approach is appropriate for this restricted building if the board thinks that's necessary.
I would welcome it. And what I would also welcome, obviously, he has every incentive to get as much revenue out of the building as he can. Just if they're up against the caps already and they're renting every unit for the maximum allowable, or if there's a difference between maximum allowable and what they're actually renting these units for. Just that slight distinction I'd be curious of.
Yes, he can address that. And Kent, I would ask you also to explain a little bit about the complicated financing for these buildings. They're built with the public money. Actually, it's a tax credit, and Kent can explain. But there's a tax credit period, and realistically, these owners don't sell these buildings during that tax credit period. The expectation is to hold the building during that tax credit period. And that's why they're just holding it for the income. There really is not a resale a value during that restricted period, or it's very complicated. Can you address that and Mr. Johnson's other questions?
Yes, definitely. Appreciate you having me on. So when we value these properties in each of the counties, something that often comes up is the income approach versus the market sales approach, which is what Michael was alluding to, and then the cost approach. Well, in each of these approaches, from an appraisal perspective, you have to consider what is the highest and best use of the property, or what is the intended use of the owner. And the problem with market sales approach is that we have a 15-year compliance period where the property incurs liability for these tax credits that they receive over a 15-year period. So you'll very seldom see a property change hands in the first 15 years because there's a recapture risk. If we were to sell the property to another owner, and they, for some reason, weren't compliant, they could come back and take the tax credits back that they've already issued to us. And so the market sales approach is a tough one. It's not one that we look at, especially while the property is in its initial 15-year compliance period. The cost approach is, I think, the standard set forth by statute for commercial property. The irrelevance in the cost approach comes with the fact that the property isn't being redeveloped. It's not construction cost. The true intended use of the property is as an income-derived project. And so this is why the income approach is the most reliable and useful method when valuing the intended use of the property. Regarding the rent restrictions, those run for the remainder of the declaration of the land use regulatory agreement. And so when that change took place to amend the LURA, or the land use restrictions, it changed the period from a 25-year extended use period to a 40-year. But that what's called the applicable fraction didn't change. That 4 of the 40 units remained market rate. In regards to what's charged to the tenants versus, you're absolutely right that we do want to maximize our income given the limitations and restrictions on rent. I would say there is some variance that at times the rents are lower than what's required by the regulatory agreement, but in most cases, and to be financially feasible, we try to avoid that situation. and find qualified tenants that we can charge the maximum amount available.
Okay.
So this is Al Plank. I got a question on the income approach from your perspective. Isn't the reason, a portion of the reason that people invest in these is for the tax credits? And so it's almost a substance over form look. It seems like, you're not going to make money from the net income of these properties, but there's more financial benefit derived from the tax credits, and that's why people invest in these. So would there not be a factor for those tax credits in determining a net income approach?
It's a great question. I think it varies from state to state. The way that these are financed is that almost completely, almost the entire construction cost is financed through the federal government. And so we go through an application process based on feasibility and to make it simple, it's a federal program. It's federal tax credits. The state housing agency determines which of the applicants has the most suitable practice or model for this to work, and then they award these tax credits. And depending on the state and the statutes, those tax credits can come into play during the valuation, or they may not. But it tends to vary from state to state. For example, in Idaho, they do have us add the tax credits, the value of the tax credits to the assessment, but it's after capitalization. And so they've kind of negotiated a middle ground there. But as far as I can see in the state of Nevada, I don't believe that the tax credits hold value when it comes to assessment.
My question for you will be relative to capitalization rates. I just want to make sure I'm understanding all of it. You, in determining your value by the income approach, you added back in taxes. So you're going to assume your analysis is predicated upon the appeal being successful and you guys being exempt from real property taxes. So you're adding that back in, which that makes sense to me. Then the capitalization rate, you determine a 6.5. So some guidance there relative to how you determined it. And you add a loaded factor of 122 basis points, but that says it's for an effective tax. So I want some explanation there, because if we've dealt with property taxes up above, why are we going back in and loading the cap rate for them? But I'd welcome you walking us through that.
Definitely, and it's not something that has to be done. I think the county's approach was to expense the taxes and to use the base rate of 6.5% on the cap rate. I believe when you do that, it actually comes up with a value that's favorable to the appellant and to the owner. The reason we did it is just because we work in 7 different states. When I did this valuation, I did what I'd seen was typical and common among other states. It's not something that has to be done, but the 6.5 base rate came from just a general sense for the cost of capital for financing costs, and it was a number that was a little bit lower compared to some other states. So that's why we went back and added in the tax levy rate. It's really arbitrary based on the state how they do that. But whether we expense taxes and use the lower rate, or whether we do the loaded cap rate, it doesn't really matter to the owner.
Okay.
So this is Bob Schiffmacher. I have a different but kind of related question. So the property tax exemption addresses those units that are rent restricted. 90% of the units, or in this case, 36 units. The balance of the property, the remaining 4 units, are not rent restricted. If you adjust the indication of value from the income approach, if you adjust the income to use the actual income as restricted, and then apply the 90% or the 10% to that number, doesn't that result in a double dipping of the tax benefits? Because we've already reduced the taxation or the taxes based upon the exemption for those units that are tax restricted. And the only way to value those non-restricted units is to use market, not the restricted rents, because those have already been addressed.
This is Michael Matuska, and that's a good question too. I would just submit, however, that the goal is to value the building, not the individual units. Percent of the building is exempt, and granted, this is a little bit unique because there are other low-income buildings, rent-restricted buildings in Carson City and around Nevada and around northern Nevada. Almost all of those are 100% restricted, so we don't really go through this analysis of how to value the remaining percentage, and that's what we're doing here today.
But Mike, let me interject for just a second. If we were to value the building in fee simple without the restrictions in place, and then apply a 10% factor to it for that portion of the property that is not deed restricted, that would result in a number that would be applicable to the non-deed restricted portion of the property. If we, on the other hand, value the property using all the deed restricted rents and make that calculation running through, then if I interpret the numbers correctly, that would result in both a tax reduction as the result of the exemption, the 90%, but also affect the valuation of the non-restricted parcel or portion.
Just to clarify a couple things, and Ken can weigh in on this also, but the actualized rents shown on the income statement are for all 40 units.
Correct, but that number, 90% of the income that's reflected in there is the result of the deed restricted or the reduced rent component. And so you're diluting, if you value it based upon the deed restricted rents, then you're diluting the value of the non-deed restricted component.
I think the 90% comes up again, just because that's the number of units restricted. I don't think there's a way though to say that 90% of the rents shown are from the rent restricted units. And what's a little difficult here, and Ken can weigh in on this, the deed restrictions do not identify the rent restricted units. Ken, you can explain that, but the units change. So I'm back to the point that we're not trying to value the units, we're trying to value the building. And the assessor, I think, agreed to value the building as a whole.
Which is what I'm suggesting, but based upon the market rents, because that's the way to establish the overall taxable value of the property. Then from that, because of the deed restrictions, the benefits to the property owner are the reduction in the taxable value by 90%, or the taxes by 90%, which is the exemption. The remaining 10% on a gross basis addresses that portion of the property as it changes through time of the units that are not deed restricted. Well, and I understand that unit number 3 might be deed restricted this year and unit number 12 might be deed restricted next year, but we're using this as kind of a gross calculation of that 90% of this is deed restricted, 10% is not.
Right, but we are asking the board to consider or reconsider this decision that, well, I have to clarify even that. The county assessor did not apply the income approach. I explained why. County assessor, using the market rents, explained that that might actually produce a higher value. But when we apply the income approach, my understanding per statute in the administrative code is that when you apply the income approach, you have to look at the actualized income and not a projected or market income. So this is the actualized income per code and per statute that would have to be used to value the building pursuant to an income approach.
Okay.
I think that that's kind of our starting point, and I would submit that that's a legal restriction that this board is operating under, that we're supposed to look at the actualized income, and that was our conflict with the county board. And we would probably be satisfied with a resolution that instructed the county assessor to apply or evaluate the income approach using the actualized income, and whatever the other standard method, whatever the other standard methods are would apply as far as cap rates or adding the tax back in. But the resolution that we are requesting is that we use the actualized income when we calculate the income approach. And I believe that's what's required by code. And honestly, that's the end of my presentation. If Ken has more to add, he can. But just to explain again that we know that we know what the record is at this point, and we know that Christina Court did not submit an application for the tax exemption until the 2019-2020 year, which was submitted shortly before the hearing before the county board and approved shortly after the hearing before the county board. However, the reason is what we've been explaining. First, the county assessor informed Christina Court they were not eligible for the tax exemption because the building was not 100% income restricted, and that's in our record. And later, they advised that they weren't eligible for the tax exemption because the LURA, because the land use restriction had been released. Both of those are mistakes about the legal characteristics of the property, which warrant the assessor going back not just for the current fiscal year, but for the 3 prior fiscal years. Again, the legal authority is NRS 361.768. Based on mistake, and this was a mistake, the assessor can go back three years, and that's what we are asking here. I would just offer that Kent needs to correct anything about the valuation or the restricted units he can, but that's the end of my presentation. Ken, was there anything more on that? Maybe we lost him. I'm not too worried.
I think he's on mute.
I think we covered it. I think we covered it.
I think you did a good summary. Given the time that we have, I think that was a good synopsis of of what our expectations are from an owner.
Great. Any questions from members of the board of either Kent or Mike? Seeing as none, I'm going to go to the assessor's office. You guys do have rebuttal time, and I probably will have some questions for both of you at that time. But with that, Carson City, love to hear from you.
Thank you, members of the board. Again, Kimberly Adams with the Carson City Assessor's Office. Where to start? Back in March, there was a restrictive deed that was removed terminating the low-income housing tax credits. We were notified of that, and at no time were we told that there was a amended version of those tax credits. I would also like to direct you to, and let me find your page.
And when you said back in March, you were talking March of 2011, correct?
2012.
Okay.
So according to the recorded documents, there was a termination recorded, then 5 days later, the amendment was recorded. These type of documents are not a document that the assessor's office is going to search for. We're not going to print. They don't affect title. They don't affect ownership changes. They don't affect anything as far as maintaining the ownership of the assessment roll. So it's not a document that we're searching for. That being said, this company, Somerset, they also own a property right next door, and I'm trying to find my exhibit, pardon me. There's so many pages here, it's hard to keep track of. So their property right next door, they also have low-income housing credits that they are receiving. They also have near the same year of construction, which is about 2012. They applied for the low-income housing tax exemption, which they obtained the application from our website, turned it in a timely manner, and they've been receiving that low-income housing tax credit since that time. Now, again, this property is located right next door to the subject property. Regardless of the recorded documents that terminated or amended the restrictions, there was never an application provided to the assessor's office requesting for the low-income housing tax credit. And
is that generally something that's due June 15th of each year?
That is correct. It's due June 15th every year.
Per statute.
We provide them via the website. We will mail them to them upon request. So it's not that the property owner was not aware of the process, because they had already completed that process with their other property.
And they have to, and sorry if I'm being just too redundant, but that's something they have to apply for every year, irregardless of what happened the prior year.
So they apply for the initial exemption every year, or at one time. Then every year they have to confirm the number of units that qualify under the 4060 rule per statute. We provide that form to them, and they return it to us before that June 15th deadline. And then the exemption is applied based on the number of units that qualify or don't qualify.
Okay.
And so that application, again, was never provided to our office for the Christina Court property. But they did apply for the property next door, which is 002-10189. We received that application in a timely manner on June 18th, 2012. Oftentimes, these low-income housing projects will apply for the exemption before construction is even completed to ensure that they will have that exemption when they have the units rented out. We have that exact same situation on Hot Springs Road, brand new low-income housing unit. They applied last year with the understanding that they will not be eligible until the 21-22 year, because it is not just got completed construction at 100%. At no time did we deny that exemption. There was never an application to deny. We follow everything consistently. We always provide an application if requested. That's why we make them available online. So to say that there was an error involved, it had nothing to do with the restrictions. They never provided an application.
And a more global question, within your office, you guys have quite a few affordable housing tax credit projects in Carson. Do you guys ever give the tax exemption without someone having affirmatively asked to renew or asked for it each year? Or is that something there's always a form filed, either a request for renewal or the initial application before you guys grant that?
Once the initial application has been received and approved, we provide the renewal form.
Okay, but they have to submit it.
Correct. There's nothing usually on a grant bargain sell deed to indicate, oh, this is a low income housing project. It normally isn't notated on the grant bargain sell deed. So it wouldn't be something to warrant us to send an application. That being said, if we have a church purchase a property and it says, you know, a nonprofit entity, so forth and so on, we do provide them with an application so that they can fill it out.
And then after you guys grant that, so June 15th, leading up to the start of the next tax year, 2 weeks later, 15 days later, I assume, do you guys provide some correspondence to the property owner indicating we've received and processed, approved your request for tax exemption for the next tax year?
Yes, we do.
Okay.
Yes, we do, either via email. Usually a hard copy is provided also in the mail stating that they were approved. We usually correspond with them, letting them know that their application has been forwarded to the district attorney's office for final approval.
And that's something that a property owner back in November, December of the prior year, when they get their notice of assessment, they realize here are the taxes if I don't, and that's what's going to be calculated based on if I don't get the exemption. So there's notice throughout the year to the taxpayer.
They would receive an assessment notice indicating that there was not an exemption being applied. Yes, in December, early December.
You'd mentioned something earlier that the property next door was, you'd received the initial application in 12. Have you received the annual confirmation applications in the subsequent years on that next door property?
Yes, I have.
And just to follow on, that's pretty well understood by owners of affordable tax credit properties that they have to submit every year in a request for renewal. Is my understanding.
Yes, I would agree with you.
Okay.
And there were several, as you see in the record, there were several years of correspondence back and forth. At no time throughout those emails between us and the petitioner was it ever brought up that, oh, well, that terminated restrictions, they amended it, and here's the recorded document. That document was not provided to us until the petitioner appealed to the County Board of Equalization, or shortly prior to them appealing. That was the first time we had ever heard of the amended restrictions that were recorded. And again, it's not a document that we would search for in the recorder's index to, view, to see if it affected anything that we were needing for ownership changes. It's not a document that affects ownership changes.
So this is Bob Schiffmacher. Is there a mechanism? Is that June 15th a hard deadline, or is there a mechanism in the system to allow that form to be filed retroactively? Or is that an absolute hard deadline?
According to NRS 361.155 Section B, the initial claim for a tax exemption on real property acquired after June 15th and before July 1st must be filed by July 5th. That's the only little pocket of leeway there is. But if they had purchased the property prior to the June 15th deadline, then the June 15th deadline is applicable.
Okay. And then
so that's in the same tax year. It's not there's no retroactivity that would accrete to the property for prior years. That's a 15-day or a 30-day extension based upon the acquisition of the property in the tax year at question.
That is correct. The only caveat to that, if I'm using the correct word, would be if they had applied for the exemption, had been denied by our office for the upcoming tax year that would begin July 1st, they could have then appealed to the county board for that denied application for the current fiscal year instead of the upcoming fiscal year, if that makes sense.
Yes.
Okay.
So where do we stand now? What's the next topic of discussion regarding this case?
Well, I do have Bryce here who prepared the income statement for our office. If we can, I would like for him to discuss where he came up with the valuation and discuss that part further as far as the assessor's office is concerned.
Yes, that would be our preference as a board.
Thank you. For the record, Bryce Wheely, Carson City Real Property Appraiser, and completed the income model that we relied on. If I can quote statute real quick as for how we arrive at the taxable value for the property. Any person determining the taxable value of real property shall appraise, and this is NRS 361.227. We shall appraise subsection B, any improvements made on the land by subtracting from the cost of replacement of the improvements all applicable depreciation and obsolescence. We use obsolescence for buildings that are underperforming economically, which is where we rely on an income model. Section 5, subsection C, capitalization of the fair economic income expectancy or fair economic rent, or an analysis of the discounted cash flow is how we would analyze how much obsolescence to apply to an underperforming building. We collaborated with other counties in the state, including Washoe County, to confirm that they were using the same methodology of relying on fair market rents as the basis of our income for the property, where we arrived at the net operating income or the effective gross income of $420,450. And those incomes are based off of the in-place revenues for units 103, 107, 207, and 314. Aside from that, that difference of using in-place market rents rather than the aggregate in-place rents, we adhered wherever possible to the appellant's income statement, and even chose the more conservative method of applying the taxes as an expense rather than capitalizing it back into the cap rate. And so we arrived at a suggested economic value of $3,314,431, which is above the current taxable value.
So if I can just stop you there, I want to make sure I'm understanding the thought process. And by using market rents, what you're saying is that there's another value component here, and those are the tax credits that got sold, whatever happened, but that's the only reason this property is being rented and deed restricted for less than market rent, but we need to capture that. You guys are essentially saying that's taxable. That's how everyone else is doing it.
And Member Schumacher hit it on the head, is that if we were to use the in-place revenue and then also apply a 90% exemption, it would be double dipping on the benefits of those deed restricted units.
Okay. And that's, I mean, it sounds like you went to Washoe, who they've got even more tax credit properties than you do in Carson. And you said they use the same methodology that you're using.
Correct.
That's correct. Okay. And please continue. Sorry for interrupting there. I just want to make sure I was clear.
No, that was what I have.
Okay.
Those two sections of statute saying that we start with replacement cost new less depreciation, and it's substantiated by the income model. But ultimately, the taxable value that we rely on is established by replacement cost new less depreciation.
and I don't know if it's going to be relevant here. What's your opinion of a cap rate for an apartment complex in Carson?
No
6.5.
I beg your pardon. We found no compelling evidence to vary from the 6.5 cap that was provided by the appellant. So we proceeded with that assumption.
Okay, but that would be, I mean, largely in my view, that's probably a generous assumption. You guys are just saying there's no compelling evidence, so you're giving the benefit of the doubt. But would you agree that you're giving the benefit of the doubt with using a 6.5 cap rate?
It seems very reasonable. Yes.
Okay. My question, I just want to be clear because things are moving around. Sorry about that. For the 3 tax years in question here that are being appealed back, none of those tax years was there a timely filing for initial tax exemption or renewal of a tax exemption for this property. Is that correct?
That is correct.
Okay. Those are my questions, but the remainder of the board, do you guys have any further questions from Carson City?
I'm satisfied.
Okay. Al, Bob, anything from your guys' end?
The 2 parties have answered the questions that I had regarding both of the issues at hand.
Yeah, I think I'm good too. It might be a good gut check to get back with the appellant at some point and make sure that we're addressing their key points, because it seems like some of this didn't get resolved at the county level. There were some unanswered appeals.
Okay. Well, without that, anything further, Carson City, before we go back to the appellant?
I just have one more small thing I'd like to bring to the record and to you as the board. It would be SBE 400. It's one of the earliest emails that we received from Somerset Pacific. And hopefully on your copy, there's a highlighted portion from Pat Parker stating that Christina Court, this property is brand new. We are leasing it now and should have our first tenants next week, Tuesday, January 8th of 2013. This property will have low income and normal income folks. It does not qualify for tax exempt property taxes because it is not 100% low income. Those are their words. And then if you look further down on item 4, she discusses Sierra Ridge, and this is the property right next door. She's discussing possibly about an appeal. We did not need to appeal for the January 15th deadline. This piece of property is exempt for 2012. Notes concerning this property, it's a new property. The property is tax exempt because it's 100% low income senior citizens, but you must file a form every year. So as far as the assessor's office is concerned, they knew exactly how and where to find the exemption application. She even notates it in her notes in that same paragraph as to where to find the application for property tax exemption that she had saved in her own documents as a hard copy. So I would just like the board to be aware that this was January 4th of 2013, an email between Pat Barker and Dave Dolly, the assessor.
Thank you for that. Without anything further from the board, let's go back to the petitioners. And I think you've heard, and I hope it allows you to refine your comments based on our discussions with Carson City.
Well, it doesn't really.
Okay.
But Ms. Adams mentioned Exhibit D last, that email, so I want to go back to that. She made those same statements before the Carson City Board, and those found their way into the decision. And her reading of the record is backward. Those are not the words from Christina Court. That email is to Dave Dolly. I would like to confirm our conversation regarding these properties, goes items 1 through 4 to confirm the conversation with Dave Dolly. The conversation was that Christina Court is not tax exempt because it is not 100% restricted. but that Sierra Ridge, the sister building, is tax exempt. So the record needs to be corrected. That's not Christina Court's admission. That is recounting a conversation with the assessor. And now I need to go back to finding of fact number 9 in the decision, which is not supported by the record. Finding of fact number 9 says a number of things, including the application is available on the website. I would like the assessor to confirm, if they can, whether that's actually true, because when you go through these emails, the assessor had to send the application to the property owner in that 2012 timeframe. Looks to me from these emails that it went on the website sometime after that. So absolutely, make no mistake, the property owner was relying on these discussions with the assessor, which gets us back to the mistake issue that I identified in the statute. But also finding of fact, a number 9 from the decision from the county board says, not at any time did the assessor's office tell Christina Courts that they were not eligible for an exemption or discourage them from applying. That's contrary to what we just looked at in the record. We're in a phone call with the assessor. The first phone call was that Christina Court is not eligible. Reason is because it's not 100% tax restricted, but that Sierra Ridge is. Then we go through the record. In 2016, they changed the reasons. We looked at the next exhibit, that Exhibit K. We already looked at that, where the assessor says that it's not eligible because the LURA, the land use restriction, was released. It was not released, and that's a mistake. Ms. Adams comments that they don't have a way to search for that, or that doesn't appear on title, or would only appear on a title report, quite frankly, is irrelevant to the question of whether that was a mistake. It was a mistake. So multiple times the assessor told them that they were not eligible and discouraged them from applying. So that's why we have the mistake. And then I'd like to address the income approach a little bit. I think we got off track a little bit. The discussion of double dipping has never come up before this hearing. So that was not the concern expressed at the hearing before the county board. And I would suggest too, the concern about that is a little misplaced. And Mr. Merzlock can offer as much testimony as need be on the issue, but those tax credits are calculated as part of the building cost and are relevant to the financing. The tax credits are not income. So that's not correct. And the idea that we can use the market approach is contrary to statute and code. I'm looking at the Nevada Administrative Code 361.423, which identifies net operating income at least 4 times. And then it has a provision that can be adjusted where the operating income is cyclical. We don't have that. We need to be looking at the operating income, not the market rent. So any idea that that's what other assessors do, I'm sorry, but that's beside the point. By statute and code, we should be looking at the net income. But I've already, and the appraiser identified also that when he does his income approach, he has to consider a factor of obsolescence. We would agree with that, but obsolescence can mean a legal restriction, such as the LURA. So even doing that, you still have to consider the LURA. There's no way to avoid that. So what they really did was a market approach for an unrestricted building that does not consider the legal restrictions. That's not an acceptable application of the income approach. And just to conclude where we started, in the case of an overassessment, due to factual error concerning zoning, legal, or physical restrictions, the assessor can go back three years. And we have that here. I guess I should recap though. They did get the exemption for 2019-2020 fiscal year. They did not get a revaluation for the 2019-2020 fiscal year. So we didn't even get a revaluation for the 2019-2020 fiscal year for the remaining 10%. So certainly they should get it for the 2019-2020 fiscal year, but under 361.768, also go back 3 years.
Mike, from my end, so the property owner, in your view, was relying on the assessor's office that they didn't qualify, so they didn't even bother applying. And then at some point they employed you or somewhere else and said, no, wait, I actually do qualify. I'm going to force the issue. What is the background there? Because they didn't apply for a period of time for the tax exempt status. I think you're going to tell me because they didn't think they qualified. But any more context you can add to that?
Kent will, but he's going to explain that more recently they started to realize or question this statement that the LURA had been repealed and verified that it had not been repealed and started to pursue it then.
And it's not that we knew that there was an application and didn't apply or didn't bother to. We were getting annual renewal forms on this property every year. We had to explain which units were rent restricted, which ones weren't. We did file annual forms for this property. The missing piece and the misunderstanding was that initial application. But and what we've tried to portray here is that until we do rely on the assessor's office to administer the application and to help us through it and to process the application, but until the mistake about the LURA being until they realized that it was an amendment to the LURA and not a termination of the LURA, they were in no position to be able to offer, the application, to offer guidance. And so here we are, confused, filing annual forms for this exemption, not understanding how it works. And on the other end, the assessor's office is under the understanding that this isn't rent restricted because the LURA has been terminated. It just became a mess, and my point is that we couldn't file the application. We couldn't file it until we were both on the same page. Both parties had to have a full understanding of what was going on with the property, and until the land use restriction was corrected and understood by both parties, only at that time could we move forward with an application.
Okay, so that's why you didn't file for 15, 16, 16, 17, and 17, 18, just because you felt like foundational issues needed to be decided first before you would be eligible to apply for either the first application or renewal thereof for the tax exempt status.
Yes, thank you.
Okay. What is the second component is for 1920 saying that it should have been valued in accordance with the market rate units, the 4 market rate units should have been valued in accordance with your DCF that is 90% deed restricted. What I'm going to guess the county did was they added to the rolls 10% of the value to account for the 4 units, 10% that are market rate. what they do wrong there? Because they shouldn't take a DCF that's weighted 90% towards affordable, or direct capitalization analysis rated 90% towards affordable, and use that for the 10% that are market rate.
I think well, go ahead.
I know what the chairman is asking, but I just have to repeat what is in the code and in the statutes. We look at the net operating income. That's been provided, and I think everyone's agreed this building is being valued as a single simple. So it's a valuation of the whole.
Okay.
Yeah, those actual income numbers that we provided to the county, they account for both the market rate and the rent restricted. It's not necessarily one or the other. And I understand your point about, okay, there's an exemption on that portion, but regarding valuation as its own separate topic, I believe appraisal methodology would support that the actual income derived from both the market rate units and the rent restricted be considered in the valuation.
I think it has to be if we apply the Nevada Administrative Code, which asks for the net operating income, and we value the building as a single unit, as a whole.
Okay.
We're not offered a method that I'm aware of.
Okay. Is there more from your end before I ask for questions from the other board members?
No, I thank you very much. This has been I know a considerate board, and this is a little bit of an unusual issue. And please just appreciate in the record, it starts to become an unusual case because most of the low-income buildings are 100% restricted. So we started off right on the bat, confusion, when it's partially rent restricted.
I very much have sympathy there. Other board members, do you guys have any questions, clarifications before we close it for discussion?
Mike, I apologize. Can you I have finally, you might have noticed me coming and going. I finally found my copy of the NAC and the NRS, and I'm wondering if you can point me again to the applicable section regarding the income approach.
Um, 361.423.
Is that NAC or NRS?
NAC, yes.
Hang on just a second.
I think it's in there in other places too, but that's the one that I was looking at.
361.423.
423.
423. Okay, so.
And I would offer you though also NRS 361.2285, the income approach is supposed to consider the obsolescence also. And the county appraiser identified that, but the obsolescence should include the LURA.
My question, why Bob looks at this, is just to make sure I understand specifically the relief you're requesting is for the 3 years, starting with 15-16, 16-17, 17-18. You want us to go back and say under 361-768 that there's a factual error made, and these properties are in fact tax exempt for those 3 years. And then for the 1920 tax year, use the direct capitalization model that is, I believe, SBE 323 through 325, the property owners, and have that utilized to value the 4 market rate units for that tax year. Is that a correct understanding?
Yes, as to the first part. As to the second part, I don't actually have, you referred to a Senate bill?
Oh, no, SBE is State Board of Equalization file. So what I was referring to is the property owner's income statement.
Yes, okay. Yes, we would want that value applied for the 2019-2020 fiscal year, the 2020-2021 fiscal year, but also back 3 years on that same issue of mistake.
Okay.
I don't want to quibble though, but again, we're not looking for a value of the 4 units.
Okay.
We need, I believe that there will be a valuation and 90% of that will be exempt.
Okay. That makes sense to me. The thing that comes to my mind, and one of the sticking points, is going to be the value of these tax credits. So the reason there is a reduction in rents is because a property owner got tax credits that have value. They may have sold, they may have held on to them, but there's value there, and that was a portion of what incentivized them to spend the money they did to build this property new. And then under your guys' methodology, that value just disappears with the tax credits. I struggle with that a little bit on the surface.
If I can offer, first of all, then, perhaps if the resolution were that the assessor should review this under the SBE, perhaps we can factor that in somehow and see what kind of a difference that really makes. I don't know offhand. I would offer, though, that I wouldn't want to concede that is the correct approach for the reasons I stated. I mean, factoring those tax credits doesn't really appear in our Nevada Revised Statutes or Nevada Administrative Code. And the way these developments have been explained to me, those tax credits are really important in the financing for the building. I'm not sure they really show up as income to the owner. That's a very complex question. I will grant you, though, that's not in our record, not in any detailed terms. Okay. So perhaps if the resolution or instruction was for the assessor to go back and review this, we could provide it then and cover it then. That really is side of the record that we have here. I'm not sure that would be an accurate approach, though. And I would offer too, I mentioned the word, the obsolescence of this. That is a term that the appraiser used. The obsolescence can be a legal restriction, which would be the LURA again. So I think however we approach it, the LURA has to be factored in here. So I don't know why we would factor it in and then come up with a method to factor it back out.
Yeah, it's definitely not an easy one.
No, I mean, if I understand you right, as far as factoring obsolescence in and then factoring out with the federal tax credits, it does seem counterintuitive. However, it does fly into looking at the property as a whole. If you're trying to value the property, you'd want to take in both aspects, any detractors and any adders that make this property have some value, some numeric value.
Well, you might be proposing a third result then, where we might say that the appraiser should not have used the market rents, but you're questioning if or suggesting that the applicant's income statement should have factored in some other factors. So that's possible. We don't have an objection to reviewing that. It's a little beyond what we can do today, though.
Oh, absolutely. And like you said earlier, it's a very complex. I've seen these before and actually owned part of one at one point in time. And it was very complex. And just, I think the goal here today is just to get to the appropriate taxable value. And there's several components to that both detract and add to it from some starting point, add to and detract from the value of this property.
Yes, yes. And yes. And perhaps we're at the point where perhaps the board has a resolution on how to value it, or perhaps the board will direct the assessor to review it again with the applicant. I don't know. We would be happy to cooperate with this board or with the assessor, of course.
Any other comments from the members of the board before we close it and discuss? Seeing as it doesn't appear there's any more questions, we're going to close this and discuss amongst the board. I'm welcome thoughts of the board.
Ben, this is Bob Schiffmacher. Regarding the use of the income approach, I am a firm believer that using the restricted rents to value the property prior to the application of the tax exemption would result in a double dipping of the tax benefits associated with the tax exemption. The purpose of applying in this case, the 90% tax exemption is to address those units in aggregate that are not subject or that are subject to the income restriction. Using the income approach, using market rents, and then calculating that 10% factor, I think clearly establishes the allocation of the value towards the units that are not deed restricted and the associated amenities and land. And so I think that in this case, the assessor using the combination of the income or the depreciated replacement cost calculation as called for in statute, as augmented by the income approach analysis using the non-restricted rents, subsequently applying the 10% or the 90% tax exemption results in an equitable equitable tax for the property given the restrictions. The second issue is that of the prior years. My recollection is that the assessor in most conversations that I've had with them report to the property tax, to the taxpayer, that they are not lawyers and that they are not responsible for providing legal advice, and that they recommend that if there's a legal question that they contact and consult with their attorney. Lacking the application for the tax exempt status, I'm not sure that there's anything that we as a board, I don't know that there's anything that it's appropriate for us to address for the prior years.
Okay. Yeah, I don't disagree with what you're saying. That there's some unique nuances here, but clearly for the first point is establishing the value of those 4 units that aren't tax exempt, and you need to use market rents for that. There's no question in my mind that that's the appropriate way to do it. That's what the assessor's office did. And then 90% is exempt, so you're left with the 10% that's market. So I agree entirely with that. It's just inconclusive for the record for me. I'm bothered at the appearance that the assessor's office may have given some incorrect information, but I don't even know if they did. Most of that comes from a summary email from the taxpayer's representative to the assessor's office saying, summarizing their conversations, and they ask questions subsequent to specific points that they're unsure of. And if I'm writing that email, the biggest thing I'm going to be unsure of is we don't qualify, but there's no questions asked about that. And then the assessor's office doesn't seem to respond to confirm that conversation either. There's not enough to dig my teeth into that. And then it is the responsibility of the taxpayer every year to affirmatively ask for that exemption. We've seen that time and again. That burden falls to the taxpayer. And even if they didn't think they needed to, at least preserve your right by filing that form. Those are my thoughts. I think that completely overlaps yours, Bob.
No, I think that the other issue, or to augment that just a little bit, this property owner, through their property management arm, appears to have a substantial familiarity with the process, and to claim ignorance, I just don't believe that that's an adequate explanation for not pursuing this through their legal or accounting staff.
Okay, yeah. Al, what are your thoughts here?
Very much the same. Again, this, I would say the burden was on the taxpayer. They're a sophisticated taxpayer, it would appear to me, by the fact that they're even in this business, and that, waiting until 3 years later to chase this to ground.
Or 12 years later.
Well, yeah.
I'm sorry, 8 years later.
Yeah. It seems that they didn't fully exercise their responsibility in this matter as far as the 3 years back. And then with regard to the evaluation method, what Bob said is right on point.
Okay.
In my mind.
That's very helpful to me. Glenn, what are your thoughts?
I agree with Bob and you yourself, Ben, when you say that the potential taxes should be set with 40%. No, it's 90% of the units being taxed as affordable for reasons, and the other 4 units be fair market value. And I don't think that we have information at this point to cause us to go back 3 years and adjust things. I think it's just exhausted. But I think we've done a pretty good job of hearing all sides of the issue. So I'm ready to have somebody make a motion. Bob, I'll leave that up to you.
Awesome. Glenn, thank you for your comments. Those were helpful as well. Bob, my last thought for you as I go through this, just in every benefit of the doubt to the taxpayer, is they didn't file that application any of the 3 years in question for tax exempt status that they would have been required to otherwise. So I don't feel like we can get to the issue of was tax exemption appropriate because they didn't ask for it in any of those 3 years. So that's leading me to be more comfortable, and I think the decision you're about to, the motion you're about to make.
Okay. Thank you. I'm going to make a motion because this is a complex issue. I want to make sure that when I make my motion that I've addressed the issues at hand. So with your indulgence, addressing both the item D or the agenda item C and D for case number 2151, Christina Court Limited Partnership, regarding the agenda item D, which addresses prior year, the taxable values for, or the tax exemption for years 2015, 16, 2016, 17, 2017, 18, and 18, and 2018, 19. I move that we deny the property owner's appeal and leave the taxable value and the taxation for those years unchanged. Regarding the appeal, which is identified under agenda item C for that same case, it appears to me that the resolution for that year was addressed in the county board's actions, and that we uphold the values and exemption status as outlined in the county board's action, which results in a valuation of the property using the modified cost, or the cost approach, using the value of the land, underlying value of the land, plus the depreciated replacement, the cost of the improvements, less a 90% exemption, and that the application of the income approach using market rents across the board prior to the application of the tax exemption accurately represents the value of the unrestricted portion of the property. And as a result, any further action by this board would not be necessary.
Would you be agreeable? I agree with everything you said, and just augment it with the reason for the denial of the item D 15, 16, 16, 17, 17, 18, 18, 19 is untimely filing, among others, but it's an untimely filing issue as well.
It's an untimely filing of both the appeal at our board level and the untimely filing of the application for tax exemption overall.
Great. That was my only comment. Let's see if we have a second, then we can augment any further during the comment section if we need to. So there's a second.
This is Glenn Trowbridge. I'll second the motion.
Great. Any further comments on Bob's motion before we vote on it?
I think it was important earlier where Bob linked the cost approach to the income approach. They're very similar. And so one supports the other, I think is an important aspect of the motion as well.
I very much agree with that. And the property owners getting the benefit of what's most favorable income approach is still use the test of reasonableness. And it is here. It's just how it's constructed. And we disagree with the property owner as to how it should be constructed for the test, and agree with the assessor. With that, any other comments before we vote? All in favor, say aye.
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 Any opposed, say nay. Motion carries unanimously. With that, I think we're close to being done. I know we went way past what I thought I was going to be, but are you guys okay with another 5 minutes or so to finish off the cases today or finish off our calendar?
Go.
I am.
Okay. And sounds like I saw a nodding. Jeff, are there any more cases to call?
Thank you, Mr. Chairman. For the agenda, that completes the items that were agendized for today. We are scheduled to reconvene tomorrow at 9 a.m.
Great. And then public comment. Is there any public comment at this point in time? I know we're probably giving a period of public comment that we don't need to by the agenda, but I just want to make sure we're hearing from anyone. Anyone on the line, Christina, that may want to add public comment?
I just want to thank the board. I think it's obvious they wanted to do this in a diligent manner. Really appreciate the service you guys offer, and thank you.
Thank you for those comments. And I mean, you guys there was a lot to that one. So I just appreciate how professional you were and how well you and Mike had prepared. Mike did a lot of work on that, and that was evident to me.
Thank you.
Anything further from public comment before we adjourn for the day and pick up tomorrow morning at 9 a.m.? Seeing as none, I'm going to adjourn the hearing for today, and we will reconvene at 9 a.m. tomorrow, September 9th, to hear the remainder of our calendar. Thank you guys for participating.
Thank you, Ben.
Thank you, Ben.
Thanks so much.